If you want to pull over, just let me know.
Welcome back. We are talking sports and the law with Steve Moskowitz of Moskowitz LLP, a tax law firm. And we're going to start with this case involving Jerry Jones. A California judge ruled that he must sit for up to 7 hours of questioning by proposed former players that basically are saying that he knew about the painkillers and all the different things that they were giving players to keep them on the field. Now, normally you were saying a high-level exec shouldn't have to speak in these depositions, but why is he now?
That's right. Normally, you can't go after the head of a large organization because he really doesn't know. You have to go lower down people to do. But here, he advertised on his website and every place else. He's hands-on. He's the manager. He's this. He's that. So he claimed that he was hands-on. They said, okay, you're so hands-on, you have to testify. That's why the judge said yes to him. And
Jim Irsay, Colts owner, was another owner they tried to get to answer questions. Why was he now ruled not?
Because he was a hands-off guy, and the reason they tried to drag him in, there was a traffic stop where they saw some substance in his bloodstream. They said, oh, well, you have a substance. No, that's personal. It has nothing to do with the football team.
Now, the 32 NFL teams who are defendants in this case, how tough is this going to be for them to defend themselves when one of their owners, who now has maybe knowledge of this, is going to have to talk and answer questions?
That's the key to trying to get to the others, because an owner to owner, they would have a lot of knowledge that the lower ones down didn't. So that's what a lawyer does. He goes ahead, he says, okay, I opened the door. Now that I'm in this door, now I get the other guys, because now you talk to these other guys and you told them this and you told them that. That's not lower down on the chain.
All right, so our next story is involving Eagles tackle Lane Johnson filed complaints with the National Labor Board and the U.S. Department of Labor challenging his 10-game suspension. Now, he was given this for a second positive test for banned substances. He claims it's a violation of federal labor laws and his union contract. Talking about the due process that he was promised in his player's contract. Does he have a case?
No. What he's saying is that he didn't get a fair shake, he didn't get a fair hearing. But usually that's a real stretch, because unless somebody fell asleep during the hearing, that's not the case. And here, it's the second time and there's a drug test, so if he's going to go after it all, what he should say is, oh, the drug test was faulty. So here, my prediction on this is he's going to get thrown out.
Okay, our last case involving former Patriots tight end Aaron Hernandez, who is in prison right now, convicted for murder. He's facing more murder charges. He is suing a Texas-based phone company, saying it allowed leaks of phone calls between him and his lawyers. And this was back in 2014 during that first murder trial. How does this affect the case? What are they seeking?
Well, he's going to try to get evidence thrown out, saying, because attorney-client privilege, if you come and talk to me and tell me I axe-murdered somebody, by law, that's a secret. But the problem is this: those jail phones are monitored, and you're always told they're monitored. So if you tell me in my office I axe-murdered somebody, that's a secret. But if we go out to a restaurant and you say to me, Steve, I axe-murdered a guy, and the guy sitting next to you happens to work for the prosecutor's office, you can't say, well, I was talking to my attorney, because the attorney has to know better. And here, with the attorneys, you don't have to use the phone. You go into a private interview room. That's what the attorney should have done.
And that is why Steve would be my lawyer if I need help.
Absolutely.
Thanks for the time.